We have an update for you in the Idaho college student killings case. Bethany Funke, the young woman who survived the quadruple murder at her Idaho home, has agreed to be interviewed by the accused killer's attorneys. Now, she had hoped to quash the subpoena for her to appear at his preliminary hearing. Bryan Kohberger is charged with first-degree murder and burglary in the deaths of 4 University of Idaho students found murdered in their rented off-campus home on November 13, 2022. Now, Kohberger's attorney summoned Bethany Funke to appear at his June 26 preliminary hearing, saying she has information material to the charges against their client. They say that information could prove exculpatory to the defendant. Well, Funke's attorney argued they have no legal standing to subpoena Funke, who currently lives in Nevada. Now, in a motion filed on Wednesday, Funke's attorney said that her client had reached an agreement with Kohberger's attorneys to have her interview with them in Reno in lieu of appearing at the hearing. Now, the motion does not stipulate when the interview will be done. The other roommate who survived the murders, Dylan Mortensen, was not mentioned in the subpoena or motion. All right, still with me, criminal defense attorney Jack Rice and criminal defense attorney and former prosecutor Franz Borghardt. And I'll start with you, Franz. I was kind of shocked by this subpoena. My understanding is that preliminary hearings are controlled by prosecutors. They can call who they want. What do you think about the subpoena initially? Were there some ulterior motives, something else going on behind the scenes? Your thoughts?
Well, states differ from state to state as to whether or not the defendant has the right to subpoena and put on witnesses and testimony. But generally speaking, a good prosecutor is going to make it as tight and compact as they can. Now, remember, a preliminary examination for the viewer's purpose is not a full-blown trial, Michael. So I absolutely think it is strategic on behalf of the subpoena that's being issued. That being said, it's really, really dangerous to start firing subpoenas to victims this early for things like preliminary examinations, because it also creates a certain optic of you know, is the defense trying to bully? Are they trying to do something? We know that they have an obligation to defend this guy and to make sure that they dot their I's and cross their T's. I just optically, I don't know how I feel about it. But look, at the end of the day, they're going to get to do it.
Yeah, and that's really the whole purpose of the whole thing. And Jack, just for our viewers' sake, the defense has a right to speak to her. She's someone who spoke to police. She was technically a victim. She was in the house. Again, she was asleep downstairs, but she was the one who, in fact, did find the bodies, one of those collateral damage things we talk about a lot of the time. And, you know, what information she has, we do not know. Probably the defense doesn't know either. My thought is that maybe they were trying to contact her, wanted to talk to her. Maybe she was being difficult. She did talk about in her opposition papers to the subpoena that it would cause a lot of emotional distress on her part. As a matter of fact, she was trying to keep out of the whole trial, but the defense does have a right to talk to her, do they not?
They do, and that's a big part of this. At least they get to try to do so. You know, there's one thought here, Michael, that actually what this is this is a defense strategy. The idea that what you're seeing now is an aggressive, muscular approach from the defense that's somewhat scorched earth. The idea that we're going to come at everybody in this case with our sleeves rolled up and ready to fight. And so the argument is about going after her just like you're going to go after everybody else. So if you're going to get involved in this trial, and if you're prepared to testify, and you're prepared to testify against Kohberger, then you better be prepared for the kind of cross-examination, the kind of approach that a defense team like this would be willing to do to one witness who's actually in Reno. So that's a possibility, and it might be a hint of what's coming in the future.
Franz, fill me in on the logistics in something like this. Now you have defense attorneys in Idaho. They've got to go all the way out to Reno. Who foots the bill? How does that all work?
Well, if he's indigent, I would imagine the state is going to fit the bill. If he has private counsel, the defense is going to do it. The defense has this ability to do all this, but they don't. It's not necessarily at the government or the state's expense. But again, if he's indigent, I suspect that there'll be a funding allotment for it. I'll tell you, at the end of the day, she won't be fitting the bill. Now, the state should also have some prosecutors out there theoretically to, make sure that nothing, odd or funny is happening, and that may be something they can do through recording or whatnot. But you know, at the end of the day, you want to interview her, you're going to have to jump through those hoops to make it happen.
And to Franz's earlier point, Jack, I mean, I think the defense here has to be careful with these types of witnesses. You don't want it to appear that Bethany Funke is being made some sort of pawn in this larger game. I understand you want to send a message, you're going to be aggressive, that's clear. But at the end of the day, you don't want it to appear that she's some sort of pawn.
Oh, I completely agree, because I think one objective fact is this young woman is a victim too. I mean, regardless of what happens with a Kohberger case, whether guilty or not guilty, I think you can say without question, everybody in that house with 4 dead teenagers, 4 dead young college students, they are all victims. And so as a result, you have to act appropriately with them. Because if you don't, remember, what happens outside of a courtroom is going to impact the entire jury pool. When you start picking juries, all of these people are going to have some sort of connection to social media, to the world. And I think the idea that you're assuming that they're not going to have ever heard about this case in this part of the country, in this part of the state, is simply laughable at best. And if you're acting like a jerk, if you're acting like an idiot, then you could pay a price for that when you get that jury pool rolling into that courthouse.
Yeah, no doubt about it. And I think in this particular instance, that's a win for the defense. They do want a venue change. And there is a large gag order in place, a very comprehensive gag order to that end, hoping not to spoil the jury pool any more than they've already been sort of